board members, but two of them couldn't make it. So one of which is Patrick, who's our normal chair. So we'll need to have the board, for this meeting, nominate a chair and vote to have that person serve as chair for today. And then I'll turn over the chair's script to that person, and they can carry the meeting for us.
I'm going to nominate Marcia.
Oh, no.
Marcia's
just
been
behind.
nominated. She's one. There's 1 second away from, yeah. Marcia, I have a feeling this is coming your way, so.
You have the experience.
No, I haven't been here.
Yeah, she's been, she's been in a lot of these meetings and seems to be very knowledgeable. I think she'll do a good job.
Marcia, are you comfortable serving as the chair for today?
I could attempt to do the job. I've never
I'll-
been a chair as my,
Really, I'll help you.
okay.
We'll figure it
I
out.
don't want to give anyone, disrespect, okay, but I haven't been a chair, so.
We'll do it today. So I would remind you to or set your microphones so they're pretty much directed right at your mouth, so you can get picked up real well. And then the board members, if you'll vote on your motion to have Marcia serve as the chair today, how many are in favor?
Aye.
And opposed? Carries 2-0. Marcia abstained from voting. So
Okay.
Marcia, Crystal's handing you what we call the chair's agenda, and we just do it in large font so it's easy to read. You can kind of check it off as we go. This should serve as a checklist almost in steps. And I have a copy of something similar, so if we have a point of order or something, we'll just stop. We'll pause and get back.
I just want to get a pen out.
Crystal just
Oh,
brought you one if you want to
okay,
use
thank
that
you.
one.
Well, we'll call the Thursday, November 3rd meeting of the Building and Fire Code Board of Appeals. We'll call it to order. And it is 2:37 p.m., right? It's good enough. Let's see, we do the roll call, and
That's correct. It should
Okay.
be on you should be able to just go right down that list
right here.
you should be able to go right down this.
Patrick C. Carroll, this one?
So, yeah, and then you can call from right here.
Oh, from right there. Okay, got it. Patrick C. Carroll, John Maloney, Kevin Steenberg, Marcia Zillis present, Vincent Wood,
Here.
And we have Eric
Eric
stepping in.
Pedersen.
Yep, alternate.
Okay. We will now open public comment for anyone wishing to speak on items not on this agenda. Please note, due to time constraints, each person may be limited to 2 minutes.
So, Marcia, I have 2 public speaking cards.
Okay. All right. The first is Trevor J. Martinson, architect, regarding 510 North South Sepuetas. And
And
Public
Dr.
comment.
Post is here too, to just give me an extra 2 minutes if I need it.
okay.
Anyway,
Oh, Arthur Posh?
yes.
Okay, on the same item.
Right. Trevor Martinson, architect, and as you know, I have been responding to Okay, all right, we're on. Trevor Martinson, architect, representing the Haley Street and Salsapuedes shareholders and Dr. Posh regarding an issue. Right now, we're specifically going to, what, am I still on? Yeah. Specifically to the common wall between Catholic Charities and the project. Now, what has happened here is that ABR has approved the project with 8 and 10-foot high walls measured from the Jardín de las Rosas side. That was to meet HUD standards, minimum property design standards, for trespass and also for noise. Now, this is a very common thing, but all of a sudden, it was brought to your attention that they had built a completely different wall. And this is something that if we've done this and we brought it to the board's attention, why did the contractor, People Self-Help Housing, do this? Now, what happens, and you as an architect and people that have been involved know that if you change an ABR design decision, and they said an approval on this 8 to 10 foot high wall, which was there to prevent trespass and to prevent noise from going over to Catholic Charities, you have to go back to the ABR and request that you replace this. I don't think anybody is going to like this idea. And I think that we have to understand the rules and regulations of the city is that if you make a change in the approved design drawings, you have to go back to the ABR. There's no question about that. And if you'll go through, you'll see the problems that Catholic Charities is going to be experiencing from this as-built, non-permitted wall. Yes.
What is the question? I mean, what is the violation? That is it the fact that it's not 10 feet high from the Hardin side?
Yes, that's correct.
Which would make it, but it is 10 feet high from the Catholic Charities side.
I don't even believe that it's 10 feet high from that side. They played a little game of switch on this, and then they didn't. Again, we have to understand that the 8 and 10 foot high walls were there specifically to meet minimum HUD standards.
Yeah.
You have to prevent trespass, and the only way they could do that was 8 to 10 feet high walls on the Hardin's side. What you see now, what they've built, it's only 32 inches high. This is totally ridiculous. But here's what we have to do. HUD says these are minimum property standards that you must meet. If you don't meet them, then you're going to lose your funding. So here's the big problem. You have to make sure that you meet HUD's minimum property standards, and they're aware of it now. I have contacted them in Los Angeles. They want the city to take care of this. That's what we have to do. Now, what I'm suggesting to this board is that, yes, there is a problem, but it hasn't even gone back to ABR to get an approval. ABR approved this knowing full well that they had to provide trespass and noise problem protection. That's what they did. Now, what has happened here, and I don't like the idea that the city is going along with this as-built, whoops, we caught this wall. Nobody knew it was even going up until we just happened to be over at Catholic Charities visiting and said, what's that wall? And that's when we brought it to the city's attention and your attention. And we feel that this has to go all the way back to the beginning. We have to have ABR look at this and understand that there are certain HUD standards that have to be met. That's important. You've been told that you don't need to see this come back. I'm saying you have to see this come back, and I'm suggesting that you even go out with 8 and 10 foot story poles to understand the problem. I mean, I think my pictures are pretty clear, but nevertheless, this is something that has to be addressed by you, the board members.
A question to Andrew. Do we, this board, have the authority to order them to go back to the ABR?
So let me give you my recollection of how this was brought to the board's attention. And thank you for asking the question. Mr. Martinson and brought to us an appeal of a decision to issue a permit with a report from an engineer that called into question the structural capacity and design of one of the particular details of a perimeter wall. I think there were 3 perimeter wall details shown on a plan sheet, and one of them was a fairly tall wall. I don't remember the exact height of it, but it was like 10 or 12 feet. It was a good sized wall. And the board heard the item and found in favor of the city that issuing the permit was okay, with the caveat that the structural integrity of that wall. So what we did was we went back to the design team. Actually, what we did was we sent it out to a contract engineering service third party, so we weren't looking at it ourselves, just to confirm that our review was adequate. In the course of doing that, the developer or design team, someone who represents People's Self-Help Housing, decided that they didn't want to build that wall. They wanted to build a shorter wall. So they resubmitted to us. They submitted revisions to us for those wall details showing the shorter wall. And we brought that to planning's attention because this is a wall that's been approved architecturally. I can't remember if it was HLC or ABR, but one of the design boards looked at the project. So, no, they looked at the project because the project got approval and it came through the building permit process. So I'm 100% certain of that. What I don't know is when we brought this to planning's attention was I don't know what level of review planning did. That's a planning issue that is dealt with through planning commission and city planner. So we just asked the planning division, we said, hey, there's the revision. If we're going to approve this, you have to approve the revision as well, right? So whatever design review approvals are necessary that you think are appropriate, you need to make sure you have as planners, because when we issue the revision, everybody has to agree that's okay to build. We got approval from planning. They gave their approval. I don't know what level the review was. It may have been staff level review. It may have been a design board review. I don't know. I didn't follow it. It sounds like it might have been a staff level because I'm seeing a lot of head shake that it didn't go to a design board. But nonetheless, it received the planning approval. That revision received planning approval. We then issued that permit. And from the city's perspective, they've complied with all of our regulations. So from our perspective, there's no more issue. We've double confirmed the structural integrity of the wall. The wall has changed in height. It has gone through and has received its planning approval as well as its building approval, and it's on the revised approved plans for construction.
Well, then it sounds to me like this is a conflict between HUD or somebody's interpretation of HUD and the city's interpretation of the plan. So, I don't know where we would get to be involved in that.
Yeah, I have a procedural question. To me, it would be appealed, I guess, to the planning commission. If the planning, or if it was a staff review by planning, it would go to the board, but it wouldn't involve us. So,
so this has been. Let me just give you the procedural aspects of this as I see them, anyways. So Mr. Martinson and Mr. Posh have brought this issue to us on several occasions. One time the board heard it formally, gave direction to staff. We followed the board's direction and completed that. There's closure on that. Then
yes, and to be clear, I've seen your structural when you had comments regarding the structure back when, so I did review that information.
So now there are additional concerns about compliance with HUD requirements and this height of this wall, the extent of design review that are being brought forward. However, there's no appeal that's been made of a decision of the building official. So we get letters, and I respond to the letters, and I have included, did we hand this out, included? Yeah. So before you have a memo from me dated October 24th that specifically addresses Mr. Martinson's October 3rd and October 17th letters and how I've responded to them. I gave a similar type of letter to Mr. Martinson so he would know what I was giving you in general, my response to him. So he raises questions about how can the board allow approval, but the board doesn't allow approval. The board just asked my office to confirm structural integrity, and then it goes through the normal design review process, or the normal building permit revision process outside of board's jurisdiction, right? Because it's not a board item at that point. So from my perspective, what we're receiving from Mr. Martinson and Mr. Posh are additional information for the board's consideration. And the board can choose to do with that what the board wants. The board could direct me and say, bring this item back at our next hearing as an official item, put it on the agenda, and we want to hear this out. Here are the specific issues we have concern with. You could do that. But they'd have to be building and safety related. They couldn't be planning related because that's not the right venue for planning issues. So a building and safety type of issue would be the revision appears to have been issued by building and safety, and we need the building official to confirm for us through a staff report that the proper planning approvals were granted. Okay, that might be one way to address it. We don't enforce HUD requirements, so we can't validate that. Or you could have us bring to you someone from planning to tell you what happened and how it was approved. Or you could choose to do nothing and say, well, I see the issues are being addressed, and you know, it's an ongoing concern, but I don't think it warrants additional board review time.
Okay, Madam Chair, I have to go back to the very beginning of this to give you a very brief overview, and as Mr. Peterson mentioned, he has seen the structural issues that we had originally with this project was only...
I'll just add that I did not review them for structural integrity, and I take the building official's word on having it verified. So
All right.
I'm not concerned about the structure.
Okay, you may not be concerned, but let me explain this. The walls that we had that were supposed to, and what you said to the chief building official was, I want you to verify through a third party that these walls will not fall over in a seismic event. That was our only issue that we had, and it was a building issue. All right. What happened is the building official and his third party, California Code Consultants, did not verify the 10 and 8 foot high walls as was directed by the board then. They ended up looking at this as-built wall and said, oh, it's fine. That was not the original issue, and I point that out in my last letter here, which you have, that there is a complete different set of circumstances here.
The original issue a moot point now that the wall is...
No, it shouldn't be. No, it can't be a moot point when it doesn't even meet HUD minimum standards to prevent trespass and noise. I'm sorry, that's a building.
So just so we are, the conversation remains productive. We've used up all of our 4 minutes of time. The board can continue to discuss this as much as you want, and you can have whatever extent of discussion you feel is appropriate, or you can stop the discussion. But just as a matter of point of order, it's up to the chair to regulate that. So feel free to discuss it as much as you'd like.
Could I get some idea from the board what they'd like to see happen?
Well, I don't think it's the place of the board to mediate a conflict between HUD and the building department. That's what it sounds to me, that HUD has a requirement, the building department has their codes, and there's a conflict. And a third party feels they're being infringed on by this, and they want HUD to get involved. I don't think we need to mediate an argument between HUD and the city.
I agree, and I would just ask Mr. Martinson to go review it with planning and to please not bring things to us that aren't ready. I mean, this doesn't sound like it's our jurisdiction, so I'm just concerned about that. I don't want to be hearing this every week, every month. That's all.
Well,
Just respectfully giving you my opinion, it's only going to get worse.
Well, it won't get worse unless lawyers get involved. But let's put it this way. But here's the issue that we have, is that HUD has sent a letter.
Chair,
Yes.
the discussion is on us, and I don't know if you're extending time or not, but I would like to value the time of everybody here, and especially the people that are on the agenda. So I would just ask that we contain our
Okay,
discussion.
30 seconds to finish.
Sure, 30 seconds.
Okay, 30 seconds, count it. HUD has sent a letter to me and to the city administrator, and specifically said in this letter, and it's in the letter that I've given to you, is that the city is responsible for this. HUD is an overseer, but they don't get involved, but they have specifically said, and unfortunately, the city administrator is going to have to resolve this. And that's important to understand, that HUD has said the city is responsible. That includes the Building and Fire Code Board of Appeals, planning, everyone. So I just want that to be clear, okay? Thank you.
Thank you.
Thank you, Mr. Martinson. Pleasure of the board is not to have this back for a hearing, or to have it back on public comment, or,
I don't feel it's in our jurisdiction at this point.
Okay.
That's my opinion.
and
I
you?
agree.
Okay. We have,
As a point of order, just so once the chair has kind of closed the public comment, then that's kind of done. But the board cannot, just so you know, you cannot prohibit public comment, future public comment. So you can say, we really don't appreciate it, or we don't want to hear it, or, I like it, bring more. Well,
I
you
believe
can,
I said I asked.
right, but
Yeah.
just so you know, as far as motions
if
go.
we wanted to hear it again for
Yeah.
public comment.
But you could ask the question like you did, do you want to have it put on an agenda later or not? So just so you know, that's sort of within your realm to say whether you want to have it on the agenda or not.
If you put it on the agenda, I would love to hear it, okay? If it was appropriate, I would do that. But you have to file for that.
We filed again.
So let's talk about this so everybody knows how this works, right? In order to get on the agenda, there has to be a decision by the building official that's appealable, right? And it has to be within a time frame. So when we issued the building permit, there was an appeal filed within the time frame, 20 days, I think it was, and we had that appeal heard. I would have to make another decision, or my office would have to make another decision that was appealable and have an appeal filed within that 20-day time period to get it onto the agenda. There's a further review of the appeal requests that come to me. I look at them to make sure they really are appeal requests and not misunderstandings. This would, if there was a timely appeal filed on a decision that I made, then I bring it to the board on this project because, there would be a decision that I made that's appealable. So it can't, if someone comes in and says, hey, I'd like this to be put on the agenda, we tell them, like we've told Mr. Martinson, come to public comment, give them your information, ask them, tell them this needs to be heard again, and if they think that it merits further discussion, they'll direct me to put it on the agenda. That's the other way to get it on the board agenda. So those are kind of the two ways.
Appreciate your time. And like I said, I've reviewed everything you've given me to date, and I will review the rest of this, but.
That's up to it's not up to me, it's up to the chair.
Let him talk.
Yes.
My name is Art Posh again. And I do feel that you are a part of the safety. And what happens is that I don't think, the people that I've paid don't think that this wall is safe, particularly for the Catholic charities. And I'd like you to review
Is that structurally?
structurally. They forgot a lot of stuff to be a cheap wall. Thank you very much for all your time.
Now, let me ask you a question. You don't think the 10-foot wall is safe? Or the 10-foot wall, not the 32-inch wall?
What happens
You're talking about the wall that we saw
the
here
wall
2 or 3
is
months
there
ago.
now is not in the best interest for Catholic charities, period.
Based on structurally or
Yes.
minimum height and the fact that people
That's
can
bad
jump
too.
over it?
Everybody, everything. These city officials have avoided me. They don't listen to, we're just
Can I ask
past
which
that.
way would Catholic charities like the wall to be?
They want it to be safe.
I just
They
don't-
put
I'm not-
children in there, they're gonna have to be safe.
Safe is what, taller
Safe as that of structurally sound.
and structurally sound in your mind? Okay, just so I understand.
Thank you.
But it has been reviewed by.
Could I say, something? I was the one that, in that long time ago, that said, I think the city needs to go to a third-party consulting engineer, look at the rebar, look at the design, look at the size of the footing, and come back and verify that the drawing of that footing and of that wall on the plans does meet structural requirements. And now you're saying, okay, they went back and they shortened the wall from 10 feet to 3.5 feet, or less than 3 feet. Is that right? And
then
so
we
I assume that they use the same amount of rebar, the same size footing. Well, of course it would come in, because your overturning moment would change, everything would change.
Well, it's,
So I don't know why, that's kind of me like apples and oranges. I don't know why the 32-inch wall wouldn't be at least structurally safe. I can see your argument that it's not safe from a standpoint of security, but.
Well, 32-inch wall, it's 4 feet in order to be considered any kind of retaining wall. We don't really know the situation, but I mean, it
I can assure you that the wall that is in place at the finish of this project will be in accordance with the revised approved plans, and those revised approved plans and designs have been assured for structural integrity and life safety, and that we will go through whatever steps are necessary to confirm that the reinforcement and construction of that wall is in accordance with those revised approved plans. Sometimes we use non-destructive post-construction means of determining location of steel and size of steel, like metal detection all the way to,
There will have been special inspection on this already, so you might be able to request that.
so that is part of our normal inspection process.
Well, okay, another point. It seems to me that the complaint from the side of the people on Catholic Charities is a privacy issue.
So,
there's no privacy with a 32-inch wall as
No.
opposed to a 10-foot wall.
I've been given good advice from Crystal that if we want to have this level of discussion on this item, it needs to be put on the agenda so we don't violate the Brown Act. So maybe from this point, the board should, if you have questions, you want to put it on the agenda. It doesn't bother me to put it on the agenda. I just want to make sure we follow the right protocols for doing that, and that would be the board directing me to put it on the agenda because I haven't made an appealable decision within the last 20 days. So.
We would be doing that. I think we would only be doing that I would only be doing that if I had doubt in the process to date, and I don't. That's what I'm saying. And what the city's, I don't need a report from Andrew to tell me that he's gone to a third-party check on this, and that it's, I'm not, I mean, my as an architect, I mean, I think that, I consult with qualified structural engineers, and that's what's been done. And so I don't have a concern on a building standpoint. And I don't have and as far as the HUD requirements, I don't feel like that's our purview. So I wouldn't want to hear something that I wouldn't be able to make a clear decision on. That's just.
Well, it seems to me there's not only structural, but there's this privacy issue, which is the height of the wall. And I don't know why we would get into that. That ought to be a planning decision, not a code decision.
So, Madam Chair, you can ask your board members if they would like to make a motion to put this on an agenda. That might be a good way to bring closure to today's discussion. And if you hear none, then you can move to the next item. And if they so move, then you can follow that with a vote and see if it gets put on the agenda.
Okay. So I put before the board whether they feel this should be agendized for another meeting and a different hearing on what the issues are, because I'm still confused. Both it's the height and then it's safety, and then there's a lot of issues here
So
that.
before we put it to a vote, can I ask?
Well, there has to be a motion.
To see it?
Well, I feel if we're dealing, I mean, I trust Andrew's judgment as far as the way things should go. I maybe, as far as structurally for the wall and your side of what should be addressed here. But there's this other issue you keep bringing in, which is more of a, maybe an issue for ABR to review, that maybe, and not get you involved anymore, but it should be, maybe that would be a solution for you, is to go back.
But this board has no authority to direct Planning Commission or Design Review to take action. So that's why I say it has to be, because you have questions of building code compliance, that you want to have this item put on the agenda, then you can just ask if there's a motion. If there's no motion to put it on the agenda, it doesn't get put on the
Okay.
agenda or voted on. But if there is, then you can follow it.
Do you know if there's a time frame for an appeal of the decision of the planning?
There is. I don't know what they are.
Okay.
10 days?
So it's happening.
Crystal says it's 10 days.
Is there?
Well, I just think it's out of our jurisdiction.
Then it's the decision of the board to not have this brought back to us on agenda item. All in favor?
Aye.
You don't need to vote on that.
I don't need to vote
If there's
on-
no
okay.
motion, there's no motion. So
Okay.
you can, it's just public comment that has gone, longer than shorter, so.
And when I'm saying I don't want to see it, I don't mean that. If something changes, I do.
I'm
Does that make
not,
sense?
yeah. What
I
I'm
mean,
not,
as far as public comment.
Yeah.
I'm not trying to dissuade
I-
somebody from having public comment. It's your right, and I really don't, just-
have you been back to planning to discuss going before ABR and having them take it on?
So you're entering into
Oh, no,
conversation
okay.
on a topic that's not
okay.
on the agenda.
All right.
So you got to be careful
Yeah,
of
okay.
where you go. You have reached a point of closure on this public comment. So,
Go to the city council.
Go in there. Thank you.
Well, we'll now close public comment and move on to, I'm sorry.
yeah, yeah, see, you can just ask real quickly if there's anybody else that wants to offer public comment.
Oh, okay. Is there anyone else who wants to offer public comment on that item on the agenda? Okay, then we'll close public comment and move on to that. Adjournment.
I think, Madam Chair, I think it's approval of the minutes.
Oh, yeah, approval of the minutes. Do I have approval of the minutes for the Building and Fire Code Board of Appeals meeting of September 1st, 2016?
I'll make motion to approve the minutes.
Second?
Second.
Okay. All in favor?
Aye.
Aye.
Motion carries. Right. Or, we didn't make a motion.
You did, you had a motion to approve.
Yeah.
And it was seconded. Did you vote, Madam Chair?
Oh, I get to vote too?
Yeah,
Oh, yes, I vote.
okay.
Yeah. So we have the Salsa Puedes issue is now closed, and now we have 413 Dibley Avenue, and I believe you have a presentation for us. Is that correct? Or
Yes, Madam Chair, I have just a brief kind of supplement to my staff report. So I went through and put together just, I think, 3 PowerPoint slides here, 2 of them besides the title, just to help kind of give context to what it is we're talking about. So this is a property that's been in what's called a flood insurance rate map, a FEMA flood insurance rate map flood zone. A lot of times you hear people talk about the 100-year flood zone, or technically it's a special flood hazard area, and it's of a type of AE or AH, A meaning it has a 1% chance of happening in any year, and that's the 100-year flood zone. So this property has been since 2005 in the 100-year flood zone, and it might have even been prior to 2005, but we happen to have these handy in our GIS system, so we just wanted to show kind of the consistency of the flood insurance rate map, flood hazard areas for this property. As the city, we voluntarily enter into an agreement with FEMA to enforce the National Flood Insurance Program. What we're doing when we agree to do that is we're agreeing to enforce what's called the Code of Federal Regulations National Flood Insurance Program requirements on development, and in turn, the federal government through FEMA will give us, our community actually, not necessarily the city, but our constituents, access to flood insurance at reduced rates, because it's a nationalized average that they're working from. So we enforce their standards, and in turn, they give property owners the opportunity to buy flood insurance at a reduced rate. They also will provide, FEMA will also provide for the city emergency services, recovery services, disaster recovery services if we have flooding, if we're involved in the program. So this happens occasionally. You have a community like Santa Barbara that has a lot of old buildings in it, and they're built long before there was a National Flood Insurance Program, which started in the late 60s, I believe. We might have enrolled in it in the late 70s or early 80s. I'd have to go back and look. So we have this whole inventory of housing and buildings that were built without any awareness, right? Because they were built decades before, half a century before this program even existed. So the way the National Flood Insurance Program's regulations work on that is they say at the very top here, if you can read it, it's kind of hard. I clipped them off the web. But in that top one, 44 CFR 60.3 C2, they say that we're going to require that the city has to require that all new construction and what's called a substantial improvement of residential structures within these flood zones, these A zones, 100-year flood zones, on the firm flood insurance rate map, have to have the lowest finished floor elevated at or above the floor level, the base flood elevation level. Well, what this does, and then it says, or you can meet these other two requirements, which are essentially FEMA giving official waivers to the community because there's some reason that a waiver is warranted. We don't have any of those waivers. We've never applied to FEMA for like a waiver in this requirement. So what happens in this particular property, what I understand happened was, at some point over the course of time, a cellar, which was not a habitable space, kind of a utility storage cellar, at this residence was converted into habitable space of some type. And it was done without any record of permit in our file. Well, I don't know when that occurred, but we know that during, I believe it was the last, I have to go back and look at the ZIR, or the NOV for this, that we ended up having an inspector go out and do an inspection on, that's a citation warning letter. Excuse me while I look this up. January 13th, 2014. So they do an inspection and they find that now there's this habitable space in the cellar, there's no record of permit, and the owner now has to resolve that. They either have to obtain a permit to make it legal or obtain a permit to remove it. Well, when they come to our permit counter, they find out because of this requirement that any new habitable space has to be above the base flood elevation. It can't be in the cellar. So some view this as a catch-22, right? If they were to come in proactively and say, hey, we'd like to get a permit to do this because we haven't built it yet, they realize, oh, I can't because all my construction is going to be below the base flood elevation, and the flood insurance program won't let me do that. So they don't do it. But once the work's been done without permit or record of a permit, and then we tell them they need to abate it, they can't get a permit to legalize it. The only option, what we found out for this project is they have to remove the habitable improvements to the cellar and restore it to a utility cellar in order to be in compliance with this program, right, that the city administers on behalf of FEMA. So that's my understanding of what's happened. Before the board now is not the decision of whether or not it's above or below base flood elevation, because the floodplain management ordinance that is preventing them from getting these improvements permitted and made legal is appealable only to Planning Commission, not to this board. What is being appealed to the board is the notice of violation that we issued. Did we follow the right procedures in issuing that notice of violation? So I can tell you that we did an inspection, and that after that inspection, we documented the violations in the January 2014 notice of violation, and we directed them to obtain their permits. What we did not do is we did not give them their due process rights. So we had made an error in our notice of violation. So the reason this is coming before the board now is because once we realized that, we issued them a letter saying, hey, we gave you a notice without giving you your due process rights. Therefore, we're resetting the date of the notice to the date of this letter. If you want to appeal it, now you can, because we have to open up that opportunity for you to exercise your due process. And they're before us now exercising that right to confirm that the issuance of the notice was done correctly, and that whether or not it's a violation of the National Flood Insurance Program as administered through our floodplain management ordinance is the next appeal that they can make if this board finds that the notice of violation was issued correctly. Does that make sense?
in part, due process is it,
Oh,
I'm unfamiliar. Can you explain the due process?
Yes, I'm sorry, I used a term that I did not define. So whenever, in general, whenever a government entity takes an action on an individual, cites them for a violation or gives them a fine or a penalty, they also have to make available to them an opportunity to appeal that, to be heard, to contest it. When we wrote our notice of violation, we did not have a paragraph in that notice of violation that said, by the way, you can contest this decision of ours. You have a right to appeal this. And that's very important because that's the beginning of them working through their way of appeal. So they could appeal to us here, and if they're not successful here, then their due process rights continue. They can go to court, and the judge will ask them, did you exhaust all your appeal rights at the local level? And they can say yes. If they go to court and they said, the judge asks them and they haven't, because we never made them aware, the judge is going to say, well, sounds like the city made a mistake. They should have made you aware that you need to be able to appeal at the local level first.
I see. Thank you.
Andrew, has there been precedent for sending a second notice to a first notice with due process in the second notice?
Yes, there has. So when was it? March or April of this year, we found that we had issued notices for some period of time. I started in October of 14, so this was brought to my attention, a year and a half after I started, that our notice of violations didn't have this text in it that was supposed to be there. So I immediately, when I found that out, consulted with the city attorney and said, hey, we need to put a letter together and send it out to everybody who's received a notice of violation because they need to know this. And we need to reset all those time clocks so that so they have that opportunity to be heard. So we did that. We issued notices from April through July, I think it was.
Was the feeling of the city attorney's office that the setting of the clock would satisfy all the obligations?
Yes, yeah. Resetting. Essentially, it was less onerous than sending a whole entirely new notice of violation because it just covered. We put the letter on top of the violation, the notice of violation, and sent it out so that people could understand that those dates had all been reset.
That too, you sort of negate the original one and then send a new one.
Right, yeah.
So in the staff report, it refers, the original violation went out in January of 2014, notice of violation. And then you resent out on August 17, 2016, Inspector Welch mailed the attached notice of due process rights letter to the present owner.
Correct.
So since that time, they've been properly served. And
Yeah, and that's what they're responding to, is they filed an appeal within the time frame. And on September 6th, we received their request for an appeal. And then we didn't have an October hearing, so that's why they're before you today.
Okay. So is your presentation, is it
That's all.
complete?
Yeah.
Okay.
I'm available to answer questions after you hear from the appellant.
Okay. Could the appellant please come forward?
Absolutely.
Yeah, just make sure you get microphones. There.
Yeah, if you push, okay, there's just one of you, got it.
Yeah, it's on.
Thank you, Madam Acting Chair and members of the board, Mr. Stoeffler. My name is Susan Basham. I'm an attorney with Price Bussell in Parma, and I'm here today with Ruben Magallanes, who is the owner of the property, 413 Dibley. And we filed the appeal. I think you can gather from the presentation that staff has made that this has had a long history. And in fact, from mid-2014 until we received the due process notice, it was completely dormant. And it had just sort of, there was no resolution to be had to where we were. And so what I'd like to do here today is just talk a little bit about how we got to where we are, or where we were in mid-2014, and what I'd like to suggest as a reasonable approach here. Your staff report concludes with the statement that it's important to note that the Building and Fire Code Board of Appeals only has the authority to determine if the proper enforcement process has been employed, that is, correct party cited, correct code section cited, and the required documents notices issued. And the notice in this instance, which you have a copy of, with the original notice from 2014, cites the section of the city's ordinances that basically refer broadly to the various building codes. In other words, the property owner was cited under the building codes for a violation of the building codes, and there's no reference to the floodplain ordinance, and there's no reference to a floodplain violation. All of this discussion of floodplain came up later. It came up in conversation. It came up informally. There's no documentation of it anywhere coming from the city to our client. And it left him in a rather awkward position because he's basically chasing a moving target as to figure out what he's supposed to do to remedy a situation that was described in the notice of violation as unpermitted work in the basement, and yet he's not being given an opportunity to fix it without going through another set of ordinances and another hurdle. I want to just say factually that because this kind of got mushroomed into something other than what it started out being, I don't think the record ever was made clear with the city that this house, as built in 1915, is a legally non-conforming structure under the city's ordinances, and that gives it certain preferential treatment when considering the application of later adopted ordinances with which it doesn't conform. As a non-conforming structure, certain interior improvements are allowed; they're permissible. We don't deny that they may or may not have required a building permit to proceed, but there's no reason why he couldn't have had a building permit under the non-conforming structure ordinance. Secondly, he bought this house in 1990, and when he bought the house, and I think the zoning information report would show this, there were no violations of the basement cited, and yet the basement was at that time developed. In other words, the basement had been partitioned. There was a bedroom, there was a bathroom. The basement stair was narrow. It was a standard basement stair, but there had been habitable space already developed at the time he bought it, and so he perceived the house as being as that basement area being available to him for occupancy. The unpermitted work, and the only unpermitted work here, was not creating new habitable space. It was widening the stairway. In other words, putting in a safe, modern stairway that would be appropriate in a non-basement setting, and replacing the windows. And as he has told me, it was the replacement of the windows was what triggered his neighbor's report to the city as to something going on in the basement. But the history here is different from what one might gather from the sort of shorthand version of the story that's presented in some of the documentation. So our position here today is that he's never been cited for a flood control ordinance violation. If he had been cited, he would have an opportunity to avail himself of the remedies that are provided specifically in that ordinance. It has its own remedies. He could apply for a variance. He could, obtain a certificate and try to establish the elevation and so on and so forth. We also, given the opportunity, if he were cited under that ordinance, would make significant legal arguments about its applicability in this situation. But that's not even here. We're not here. We're not at that ordinance. We're only at building code violation, and the notice was served for a building code violation, not for a flood control violation. So in answer to the question, was this properly served, should your board decide that the proper enforcement process has been employed, my suggestion to you is that the answer would be yes if all we're considering is the building code violation. The answer would be no if the intent of the building official at this point is to pursue this on the basis of a flood control violation for which Mr. Magallanes was never cited. Happy to answer any questions, as is the property owner.
Yeah.
Thank you.
Does the board have any questions? And then we go to public comment. Okay.
Did the owner solicit a planning report when they purchased the property from the planning department to see if, or have a zoning report made at that time to
He
see if the
believes
house
he
was?
believes he saw one. He does not personally have a copy of it, but he remembers seeing it at the time. Yes, there was one provided, I mean, with the escrow, in the
That
escrow
would have
process.
identified that as the habitable space. It's clearly not from the photographs. It's not, it doesn't meet code in its current state.
Well, it was,
I think
yeah.
the question I would have, again, back to the city is, does the city have an obligation to give an itemized reason, or is it enough to say, to require the owner to need a permit? I mean, I don't think the city's got the obligation to give the owner a complete list of all violations, right?
Well, in so the zoning information report that's required at the point of sale is another
Two different things. right?
animal, but if I would trust that if we hear from the owner that one was obtained as part of the laws in the city, that it'd be on file in our planning file or our street file in the records room. And given the fact that we've issued a notice, I ask my staff to confirm, go back and look at the zoning information reports to see what they show as being existing at any point in time as a point of reference for us. So I'm pretty confident that the zoning information report is in our file and that one was probably obtained during the course of escrow. Just to help clarify, I agree that my presentation focused on the flood issues because that's what's preventing the owner from getting the permit that we're ordering them to get. So the work was done without permit solely because we don't see one in the file, right? No one can produce one. And when we went out and inspected the work, it didn't meet code, so it kind of further confirmed our assumption that work was done and never inspected by the city. Or we would have told them, you need to make this comply with the building code. So my jumping to I apologize for jumping to the floodplain regulations. That's the obstacle that the owner can't get over. That's, we've told them in the notice, we said the work was done without permit. You need to get a permit. Legalize it or demolish it. That's actually, it says demolish. You get a permit to demo it or get a permit to legalize it. That's what we put as the remedy in the notice. Well, they can't get the permit to legalize it. So it's frustrating for them because they're thinking, hey, I bought this property in maybe 1990, and now, maybe it was finished then, I don't know, we could look at the zoning information report and see. And now there's no permit record for it, and I can't get a permit for it because this flood stuff won't let me put habitable space below the base flood elevation. So they're
The
stuck.
building authority wouldn't preclude them from exhausting those other avenues with the flood issues if they wanted to, right? If there were
That's
some
correct.
means to be able to address those.
That's correct. So that's why I tried to set the scope in my staff report for the board. So the way I see this, and I'm open to looking at other perspectives because this is just the way I see it, is that the due process that the owner is going to go through is they're going to first have to confirm, was the notice served correctly? Was there a violation? Did the city have a reason to believe that there was no permit for this work and work was done? And did we cite the right party? Did we use the right notice? Did we go through the right steps? So we believe we've done that. And if the board agrees with that, then if the board doesn't agree with that, then there's no need to go any further, right? The notice is negated and we kind of start all over again from scratch. If the board says, no, you issued the notice correctly, the violation existed, then it's going to be the owner's due process right to be able to say, all right, now I want my permit to legalize this. And we're going to tell them, okay, well, it doesn't meet the flood requirements. Let's go to Planning Commission, or let's see if we can work on a waiver or something like that. We consulted FEMA, our regional rep, Patricia Rippey. There's no waiver we can offer. There's no way we can justify a waiver for a newly finished, and newly is a relative term, habitable space below base flood elevation. So an appeal could be made, though, to Planning Commission to say, hey, we think a waiver should be issued, and here's the reason why. Maybe the reason is, we haven't had this discussion yet with the owner, but maybe the reason is we have records showing that this has been habitable space since 1957, and the city's floodplain management ordinance didn't even come into effect initially until 1978 or 82 or something. Therefore, it's existing non-conforming. The city doesn't have a permit record for it in 1957, but they probably don't have a permit record for a lot of things that happened in 1957. So that conversation could happen before Planning Commission on appeal if that was necessary. So that's why I tried to focus on just the process of issuing the notice of violation. I jumped into the flood stuff here to kind of help you understand they can't get the permit because of that.
And the second part then is time. It sounds like it's an issue now, so I don't know how this would help one way or the other on the timing of things.
I'm not sure what you mean by time.
Well, you were making a comment regarding the amount of time that has gone by, or
Well, in fact, it's been more than 2 years since the original notice was issued, but that doesn't, I wasn't suggesting that there's any urgency because of that. I'm just saying that it's been a long process. And I'm sorry, I just want to comment on your analysis of the situation. If you send out a notice and you cite a particular statute and you provide express remedies that are available to a party, and then when they come in to exercise one of those remedies, they're told they can't exercise that remedy, then I think your burden is to issue another notice or another written communication or something that informs that party that what you said in that notice is not accurate. And that was not done here. And I think that this whole thing has become, a floodplain issue without ever first addressing the habitable space, uninhabitable space, whatever that sort of nugget of permitting concern is. It's gotten blown way out of proportion. It's the tail wagging the dog. It's now a flood control issue. And under the flood control ordinance, there is an entire set of remedies that are available. So if you're going to cite somebody under the flood control ordinance, you need to make those remedies available and give them an opportunity to exercise those remedies, and that was not done here.
I just going back to what was done. I don't think when they issued the notice of violation that they necessarily knew that it was a flood plain.
Why they needed a second one.
I don't know that it's their obligation to do that. If they find code violations and they're issuing a code violation notice, I think that's as a building authority, that's their obligation, and they've done that.
With due respect, a building code violation is very different from a flood control ordinance violation. They are separately citable. They are separate.
Pardon me, but I don't think there's a violation here yet. I think they're saying that they can't issue a permit for a property that is in a certain flood control zone, and that's not a violation. I mean, they're not. I don't believe anybody has said that the work there is currently a flood control violation, although it is. They're saying in here they list other things, and they're clearly building violations. That's how I'm reading it. I'm not reading that they necessarily even knew that was an issue at the time. And we're here, and I believe this is true, that we're here to determine if they followed the correct course. And based on what I'm saying, and we're still in discussion here, but based on what I'm seeing, it appears that they've done that with what they knew at the time.
Who's they?
That's the building and safety division that they've issued, that they've followed their. I mean, it may not be great. It may not be good for the owner. It may not be the best way for everybody. I'm sure they'll check that now when they issue these things. It's probably something that might come up in certain areas, but I'm going to guess that they didn't. Is what I'm going to guess.
Yeah, but meanwhile, this owner is stuck, and he can't proceed. And I kind of think we ought to.
How do we change that?
Well, didn't you? What were you saying, Andrew? We could allow him if you went. What I think he needs to do is give him a permit so that they can turn around, bring in this flood control problem, and then he can appeal the flood control problem to another board or whatever he has to do.
How can he give a permits for something that's non-complying?
Madam Chair, may I jump in?
Yes, please.
I think maybe, Vince, what you're speaking to is not a permit, but validate that the notice was issued correctly so that they can go to the next step, which would be to appeal the application of the floodplain management ordinance.
That's where I was trying to get, yes. Maybe I came at it from the wrong direction.
I did make a note that I will check with the city attorney's office to confirm whether or not we can offer a remedy in a notice that is not achievable. So I did make a note to check that.
And probably the point of greater concern is that the flood control ordinance was not cited as a source of violation, and the remedies under that ordinance were not offered. And just on the point made by Mr. Pedersen, the staff report, in fact, does presume a violation. So, you know, it's not enough. It's not just that there was a determination that the flood control ordinance applies. There was a determination that the property is not in compliance with it, which was the reason they didn't issue the permit. And that's where we are stuck, because, you know, it was a determination without ever being notified of what that violation, what that lack of compliance actually is, and what the remedy would be for it.
Madam Chair, may I ask the appellant a question?
Yes.
Because I may have misunderstood the appeal request. So I was assuming the appeal request was for the decision to issue a notice of violation. But it's possible that the appeal request really was the denial of the permit issuance because of the application of floodplain management requirements? Did I mix up did I not get the appeal request right, I guess is what I'm asking.
Well, I appealed it because we had a deadline.
Yeah.
And I appealed it on the basis of where we were at the moment in time where we left off, which was undecided. So it could be either. I mean,
Yeah.
you know, if you think that the difference is significant, we can talk about it. But in fact, where we left off in 2014, where we had not received that notice, was that there was, you know, no permit had been issued, and there were discussions in the air about the flood control ordinance being applicable, and no decisions had been made. So, yes, the permit had been denied. We're appealing the denial of that permit, if you want to think about it as a technical matter. We're appealing the denial of the permit on whatever grounds that denial happened. And if this goes to another level, that will be sort of the base of the appeal. And if the city's taking the position that it was denied on the basis of the flood control ordinance, then the other issues that I've raised here today would definitely be brought up.
So
Well-
is there a virtue to continue this?
Well, so yeah, Madam Chair, knowing that and kind of realizing that as we discuss this, a couple things come to mind. I'd like to review it with the city attorney's office, just the time frames and the court and what we've discussed today, sort of the nature of the conversation. The decision to not issue a permit or grant an approval, when that decision's made, then the 20-day time period starts. So that was a long time ago. So that may be difficult to overcome because that decision was made a long time ago. But the clarification of the impacts of that and what the due process rights are that are available to the property owner during the permit process merit looking through. Like I would like to go back and look through in our plan check corrections, which are the denial of issuance, right? Because you have to make corrections. If we say these decisions are appealable, because if we don't and it results in not issuing a permit, then we haven't made them aware that they have a due process right. If you follow me, we're essentially denying them a permit, but not telling them they have the right to appeal that denial.
We received no written notice of denial of permit.
Right, and we don't issue like a formal denial of permit notice, but if I hear you correctly, it's the plan check corrections that we print out and hand to someone. I'm not sure that those corrections say on them the decisions here, which constitute a denial of the issuance of your permit, are subject to the appeals, process found and yada yada yada. So if that's the case, then the board doesn't. You can direct me to do this, but I'll do it anyways because it's the right thing to do. If that's the case, then I will publish a letter to the property owner through their legal counsel to advise them that the city's made the decision that we're not issuing this permit based on the attached corrections and that's appealable, and then they can bring that back to you if they want to have that discussion. Because that isn't really how we interpreted the request for appeal because of the timing of it. We issued the letter based on the notice of violation that said you can appeal the notice of violation, not the denial of an issuance of a permit, and they responded to the notice of violation appeal period. So kind of two separate issues if you're following me. I hope I'm not being too confusing. But I'm open to confirming that they we gave them proper notice of their due process rights on their plan check corrections, and of course, any other plan check corrections we issue from this point forward if I find we're not doing that.
Madam Chair, I would make a motion to extend this so that we can do this due diligence. That would make me more comfortable than trying to vote on this at this point.
Okay, so yeah, we can move to make a motion on this.
I don't find that you're ready for that, I'm just saying.
I would like Andrew to kind of paraphrase this motion. I'm confused.
Yeah, so Crystal's reminding us, she's great at helping keep us on track of procedures. So before we go to making a motion, and there's nobody here, but
Oh.
we do need to open public
Public
comment.
comment,
So,
With that said, we're opening public comment. Does anyone in the room care to, or have a form filled out to further add to this discussion? All right, with that said,
There you go.
we'll close public comment.
okay.
Then,
Madam Chair, do you want me to try and paraphrase, and Susan can work with me here, the appellant's legal counsel, to make sure we get something that works for both of us. So, the motion is for the building official to confirm that the due process rights for the denial of the permit that was applied for in order to abate the violations in the January 2014 notice of violation. Wow, that was a big
Yeah.
preface.
good, though.
Were given to the appellant, and they were aware of those rights at the time the decision was made to deny the permit issuance. Is that it? Did I get it, Susan?
Well, that's at least one of the issues on the table.
Okay.
There may be others, but if that's the reason why.
I'm open to
the board
collaboration,
is-
so go ahead.
Yeah. Well, it seems to me that it's not just a question of whether those rights were provided, but rather the essential question that was put before this board on appeal, it has to do with the notice and the content of the notice, whether it was correct or not. It seems to me part of this board's discussion has pertained to what was known, when it was known about the structure, and the habitable space of the development of the basement, and so on and so forth. So for this board to reach a decision, it seems to me some of that additional information would be helpful. And so you might amend the motion to include further investigation of city files to determine additional information concerning the history of the property.
Like the age of the construction within the base of the cellar. Yeah, it's a good thing we record these.
You would normally do that. I mean, it's kind of open-ended.
So the question is that normal for the city to check that before we issue the notice of violation?
Right.
It is, but we haven't made that,
Comes in the violation, yes.
right, but we haven't made a record of that today for the board. So when we come back, I think what I'm hearing is, and it seems valid, that the board be aware to whatever extent is reasonable, like looking through the permit record file, of the age of the construction that was in place. Was it before the, was the denial, because the appeal's going to be, the forthcoming appeal is going to be appeal of the decision of the building official to deny the permit that was applied for in response to this notice of violation. And on the basis that it didn't meet the floodplain management requirements, and the argument, it sounds like, might be that the construction existed in the basement before the floodplain management ordinance was adopted, therefore it's not subject to it.
Okay.
So,
Yeah.
so I think that's sort of what we're trying to put into a motion is how do we get
Mm-hmm.
that back to the board?
Right, and so, yeah, so it's basically the motion is to continue the item,
Mhm.
Right.
and then for the building official, and we're trying to make this pretty concise. So, Crystal, did you type that when he?
Not all of it, no. I have
to refer okay.
back to the audio.
It was a great start, and I didn't write it.
Yeah.
We
It
can,
says
that's the,
building official to
we can get the
confirm
audio.
the denial of the applicant's, the appellant's rights. Did we follow proper procedure for noticing the violations? I was trying to catch up with you.
Oh.
You went really fast, and I mean, it seems to me that we're just going to get a continuation in order to get further information from zoning, regarding zoning, legal, building.
So let me take a shot at a condensed version.
Okay.
The board is directing the building official to return, the board is continuing this item and directing the building official to return to the board with a staff report that includes confirmation of due process rights, notification to the applicant. You don't have to write it down because it'll come out on the
Okay.
audio file. You can just say, that's the one.
Oh,
To confirm that the due process rights for denial of the permit were done correctly. And then, Susan, I'm missing that second. Oh, and the building official will also include, to the best of the reasonable knowledge, the records showing the improvements in the cellar and when they occurred relative to the floodplain management ordinance adoption by the city.
That sounds good to me.
And the property
Is that pretty
report
much-
and
pretty
the
much it?
property, The zoning.
We're not super formal, so we can,
Works fine.
okay.
I'll make that motion if
I'll second it.
Okay.
any discussion?
Any discussion? Okay. Well, call to a vote. Yeah.
All in favor?
What Andrew paraphrased, that we'll read next in the meeting minutes. So is all in favor?
All right.
Aye.
Okay. Opposed? Shouldn't be any on that one, huh? Okay.
you all.
Who made the,
I hope they give you some time and this can.
It'll be fun.
Yeah, yeah.
Thank you very much for taking the time to hear this today. I know you don't meet regularly, so we appreciate your getting
It's
together.
becoming pretty regular.
Yeah, it's becoming pretty big, yeah.
That's even better once a month now.
That's fine, yeah.
Okay.
I will, as I put this
I get on this thing for
It's
30,
been on forever, right, since it was invented?
well, yeah, Dave Johnson.
Okay, so we can make a motion to adjourn?
You should be able to go through your handy dandy checklist there.
Oh, we did the motion. Is there, okay. Is there any discussion by the board for this motion?
You already did that. You already
You
did
already
that.
did that?
You took your
Okay,
vote.
we call to a vote, that's right. Yeah, so I'm over here, motion to adjourn. Can I have a motion to adjourn?
There you go.
I'll make a motion to adjourn.
Second?
But I was talking.
Motion to adjourn.
Oh, I'll second.
Okay. I'll call to vote. Call to vote.
Oh, all in favor, aye.
Aye.
All right. Thank you, Madam Chair. You did great.